Hello, everybody. Welcome back to Patriot's History. I'm your host and the co-author of Patriot's History of the United States, Larry Schweikart, along with Michael Allen. And we have been reading through Chapter 4, A Nation of Law. And when we got to the Constitution, we stopped and began reading through the Constitution of the United States. And we're almost done. I think today we will finish the amendments here. So we stopped at the 21st Amendment, proposed 1933, ratified 1933, Section 1. The 18th article of amendment to the Constitution of the United States is hereby repealed. This is the repeal of prohibition. Now, of course, we'll get into this a lot later on. But the deal is this. Prohibition was very, very popular when passed. It had the support, obviously, of 2/3 of the people and 3/4 of the state legislatures. It had the support of the Bible Belt. It had the support of urban elites, had the support of virtually everybody. At the time, people thought that banning the sale of alcoholic beverages was going to cut down on a lot of the vices in American society. And it did. It was very effective at cutting down on liver disease, but that's about all. It did not, as has been claimed, lead to the rise of organized crime. Crime just shifted into alcohol from other things. It had previously been doing prostitution and money laundering, racketeering, things like that. But by the mid-20s, there was a major shift in the tone of the country, and they wanted to repeal prohibition. It was viewed as not working, especially the rich were able to get to speakeasies or illegal bars. It was thought at the time, as I said, later disproven, that it was part of a crime wave, especially that of John Dillinger, some of those guys, Al Capone, the Untouchables under Elliot Ness cracking down on these guys. So at any rate, the mood changed and an amendment was passed. It's very important, hard to do, repealing the 18th Amendment. Okay, Section 2, transportation or importation in any state, territory, or possession of the United States for delivery or use therein of intoxicating liquors in violations of the laws thereof is hereby prohibited. Section 3, the article shall be inoperative unless it shall have been ratified as an amendment to the Constitution by conventions of the several states as provided in the Constitution within 7 years from the date of the submission thereof to the states by Congress. 22nd Amendment, proposed 1947 and ratified 1951. No person shall be elected to the office of president more than twice. This was in response to FDR being elected 4 times. I don't care how effective you are, you need a change. That's too much like a dictator or a tyrant. And Americans only elected him in 1940 because of the potential for war. And he got reelected in 44, clearly because there was a war going on. You don't want to change horses in the middle of a war, which also benefited George Bush. George W. Bush. But now they want to end that. So no person shall be elected to the office of president more than twice, and no person who has held the office of president or acted as president for more than 2 years of a term to which some other person was elected president shall be elected to the office of president more than twice. This is, in the case of Lyndon Johnson, he had served 2 years, I get that right? And so he was eligible to run again in 68. He did not, but he was eligible to run again because he hadn't served the majority of John Kennedy's term. If Kennedy had died in 62, LBJ would have been ineligible to run. But this article shall not apply to any person holding the office of president when this article was proposed by the Congress, and shall not prevent any person who may be holding the office of president or acting as president during the term within which this article becomes operative from holding the office of president or acting as president during the remainder of such term. In other words, let's say if Truman had been elected third time, it couldn't have happened. But let's just say it could have happened. Let's say Harry Truman was on his third term. He wouldn't have to step down. He'd be able to go ahead and serve out his third term before it took effect. So they're just grandfathering in basically Truman. Section 2, the article shall be inoperative unless it shall be ratified by an amendment to the Constitution by the legislatures of 3/4 of several states within 7 years from the date of its submission to the states by Congress. So in every one of these, they're adding that 7-year timeline so that you don't have forever, infinity, to try and get an amendment passed. You either get it passed or you don't. 23rd Amendment, proposed 1960, ratified 1961. The district constituting the seat of government of the United States shall appoint in such manner as the Congress may direct a number of electors to president and vice president equal to the whole number of senators and representatives in Congress to which the district would be entitled if it were a state. In other words, District of Columbia gets electors now, but in no event more than the least populous state. They shall be in addition to those appointed by the states, but they shall be considered for the purposes of the election of president and vice president to be electors appointed by a state, and they shall meet in the district and perform such duties as provided by the 12th article of the amendment. Section 2, the Congress shall have power to enforce this article by appropriate legislation. 24th, it's still not a state though. 24th Amendment, proposed 1962, ratified 1964. The right of citizens of the United States to vote in any primary or other election for president or vice president, for electors for president or vice president, or for senator or representative in Congress shall not be denied or abridged by the United States or any state by reason of failure to pay any poll tax or other tax. Section 2, Congress shall have the power to enforce this article by appropriate legislation. That was really a response to southern states trying, mostly run by Democrats, trying to prevent Black people from getting elected by virtue of they didn't pay a poll tax or something. It was just a nonsensical way to keep Black people out of government. 25th Amendment, proposed 1965, ratified 1967. In case the removal of the president from office or his death or resignation, the vice president shall become president. Whenever there is a vacancy in the office of vice president, the president shall nominate a vice president who shall take office upon confirmation by a majority vote of both houses of Congress. Section 3, whenever the president transmits to the president pro tempore of the Senate, Speaker of the House of Representatives, his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits him a written declaration to the contrary, such powers and duties shall be discharged by the vice president as acting president. Section 4, whenever the vice president and a majority of either of the principal officers of the executive departments or of such other body as Congress may by law provide, transmit to the president pro tempore of the Senate and the Speaker of the House of Representatives their written declaration that the president is unable to discharge the powers and duties of his office, the vice president shall immediately assume the powers and duties of the office of acting president. Thereafter, when the president transmits the president pro tempore of the Senate and Speaker of the House of Representatives his written declaration that no inability exists, he shall resume the powers and duties of his office unless the vice president and a majority of either of the principal officers of the executive department or such other bodies Congress may by law provide, transmit within 4 days to the president pro tempore of the Senate, Speaker of the House of Representatives, their written declaration that the president is unable to discharge the powers and duties of his office. Thereupon, Congress shall decide the issue, assembling within 48 hours for the purpose, if not in session. If Congress within 21 days after receipt of the latter written declaration, or if Congress is not in session within 21 days after the Congress is required to assemble, determines by 2/3 vote of both houses of the president is unable to discharge the powers and duties of his office, the vice president shall continue to discharge the same as acting president. Otherwise, the president shall resume the powers and duties of the office. Okay, what's this all about? This has to do originally with presidents getting sick. You'll recall that Ike had a heart attack in 1955. And although the vice president took over the duties, that had not been actually written into the Constitution. And they decided, especially after Kennedy's assassination, where just was assumed, based on our history and tradition, as with Fillmore or with, let's see, Harrison, with Taylor and Fillmore and Harrison, and gosh, forget his vice president. Anyway, see, Jackson, Manbury, Harrison, Taylor, Tyler. Same thing that happened with Tyler and with Fillmore. They just assumed the office of vice presidency when the president died. And that was a very big deal for Tyler, the first one to do so. Because, again, there's nothing written in the Constitution specifically as to how that was to happen. So Tyler astutely said, if the power's there, I better just take it. So he walked in and just named himself president. Nobody objected. And as I recall, Tyler did not name a vice president. I have to check that. It's either Tyler or Fillmore, one of the two, did not actually name a vice president. Maybe it's Fillmore, because he only had 2 years. But we went a while without a vice president of the United States. At any rate, this is intended for sickness or illness, not as a political machination. I'll get to that in a second. But right now, at present, we have a president who, I think, with a panel of unbiased doctors, would be categorized as suffering from dementia or Alzheimer's or both. Alzheimer's is a form of dementia, actually. And I think that a panel of unbiased doctors, they didn't know what his name was. They just looked at the blood tests and did all the treatments and so I guess tests. They'd say, this guy's clearly demented. This guy's a whack job. He's a case. But of course, they won't do that. And Biden gets evaluated by his own doctor, who of course is going to say, oh yeah, he's fit as a fiddle. Yeah, can't walk down a flight of steps, can't walk across the stage without falling down, walks around like he has a load in his pants all day, gets on stage, looks around, has no idea what he's doing most of the time. But if you had that group of doctors even state it to this current Senate and the current cabinet, they wouldn't do a thing because they would much rather be ruled by a dementia patient than by a Republican. I know in some cases it's the same thing, but you know what I mean. So they aren't going to use this, but they did talk about using it against Trump for reasons wholly outside the intent of this article of the Constitution. And that was, they just wanted to rule him unfit to do his duties because they didn't like the way he was doing his duties. That's all that was. And so the word was that they were trying to assemble a group of cabinet members who would go along with a move to 25th Donald Trump and install Mike Pence as the president. And that did not fly, didn't go anywhere, but they were thinking about it. And the fact that they aren't thinking about it now tells you what a mess Washington is, because right now they certainly ought to be thinking about replacing the fellow I affectionately call the rutabaga, who is currently serving as president of the United States. Oh, and what happened, for example, with Reagan, he went into the hospital for removal of some polyps in his intestines, and he was going to be out for a number of hours, and he simply signed a declaration saying, I will be unable to discharge my duties for the next 6 or 8 hours. And then when he came out of anesthesia, it was all ready to go again, they handed government back to him. He said, I am now able to resume my duties. None of this that was written into this amendment had in mind political machinations by which you would try to out or get rid of a duly elected president of the United States because you disagreed with his policies. That's just outrageous. And I'm sure the Supreme Court would have ruled that was an unjust and illegal use of that amendment. 26th Amendment, proposed 1971, ratified 1971. The right of citizens of the United States who are 18 years of age or older to vote shall not be denied or abridged by the United States or by any state of account of age. Congress shall have the power to enforce this article by appropriate legislation. 27th Amendment, proposed 1789, ratified 1992. No law varying the compensation for services of the senators and representatives shall take effect until election of representatives shall intervene. In other words, you don't get to raise your own salaries while you are in office as a senator or representative. Now, I want to say a few words here on the ERA, the Equal Rights Amendment, because that was an important one that was, excuse me, that was not passed. And so the Equal Rights Amendment came from an idea that was generated in 1926, but it was finally passed by the House and Senate in 1971 and 1972, respectively. And so it had to go on to the state legislatures for ratification. And it was on its way. I mean, it was about to become a done deal. And this would have been pretty bad because it generated this kind of equal pay for equal work nonsense, which is never what it seems. That is, as George Gilder, the economist, once said, men almost always get outdoor work with heavy lifting in bad weather. Women almost always get indoor work with no heavy lifting. Of course, indoor work with no heavy lifting would be preferred, but women mostly get it because as a whole, they aren't qualified to do the outdoor work, Wichita lineman, ditch digger, whatever it is, the heavy physical labor. I don't care how many trans surgeries you have, you usually can't do that. And as a result, women's pay fell because they disproportionately competed for jobs of indoor work with no heavy lifting. I could explain it in much more detail, but really that's what it comes down to. Easier work. Now you can say, well, you know, accounting or calculating or whatever, that's not easy work. No, it's not. I certainly can't do it. I'm not a math whiz. But the situation in which one finds herself, namely indoor, out of the elements, no heavy physical labor required, a lot of mental work, a lot of eye strain, no question, but it's not quite the same thing as coming home every day and just aching from your physical labor. And so there were a million little things like this in the Equal Rights Amendment, these little poison pills that were going to show up to be disasters legally. But it sailed through, is almost about to get ratified, just a few states away. And that's when Phyllis Schlafly went to work. She saw the evils in this thing, the damage it would do to women. And she began a one-woman crusade against this in the Midwest mostly, and was able to stall out a number of ratifications so that it was not ratified. In fact, a couple of states withdrew their ratification. And so seeing that this was happening, 1978, Congress passed by simple majorities a joint resolution that would have extended the deadline. Remember the 7-year deadline? They put that in for a reason. They didn't want people to have forever to try and cobble together, whereas you might lose one state over here, but they forgot about it. That's why they did this. So Congress can say, well, no, we'll extend this to 1982. And the attempts failed. The extension was debated, whether or not that was legal. And then when other states withdrew their original ratification, that pretty much killed it. So But the ERA was almost entirely defeated by the efforts of Phyllis Schlafly, and we all owe her a great debt of gratitude, because this would have been a disastrous amendment. The lawsuits and the kind of stuff that would have come out of this would have been just ridiculous. All right, that wraps up our reading from the U.S. Constitution. And we're going to go back now to Patriot's history. And we're going to start on page 125. Remember, I am using the 15th anniversary edition, and the pages may be different, but the headers should be the same. So the header here is Federalism Redefined. The completed Constitution represented a marked transformation in the American system of federalism. Defined in the early state constitutions, federalism meant a belief in separate governments, state, local, national, with state sovereignty, but the 1787 document turned the system upside down. Article 6 is an uncompromising statement that the laws of Congress are, quote, the supreme laws of the land. Nevertheless, the purpose of this power, preservation of liberty, remained evident throughout the document. This achievement required the delegates to endow the natural government with a grant of specific, crucial, enumerated powers, including the authority to tax internally and externally via excises and tariffs, as we read, to regulate foreign interstate commerce, enforce contracts and property rights, raise armies in the time of peace and war, make treaties, make all laws, quote, necessary and proper to carrying out these enumerated powers. Conversely, the states could no longer levy tariff and customs duties, coin and print money, or impair contracts via debtors' laws. These changes had crucial and far-reaching consequences. So just let me go back 1 second and make a point here about the Constitution. Okay, and I'm reading, obviously, from Patriot's History Reader, U.S. Constitution. Let me go back to the preamble. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, and promote the general welfare, and secure these blessings of liberty to ourselves and our posterity, to ordain and establish this Constitution for the United States of America. That general welfare clause is often misunderstood. It's not talking about welfare as in welfare checks. It's talking about the good of the country. That's the first thing. Second of all, it is defined by those things that it just listed. You know, promote domestic tranquility and provide for the common defense. Those things are what are meant by the general welfare. And the way in which you carry out promoting the general welfare is you follow what is inside the Constitution that follows. The preamble itself is not a legally binding element to the Constitution. It's a mission statement. So anybody trying to say, well, no, Constitution says we need to promote the general welfare, it does not mean what they think it does, and it is totally limited to how it promotes the general welfare by the clauses that follow. So I hope that helps. All right, back to 125. Under the three-branch federal government, which boasted the checks and balances for which the Federalists are rightly famous, Article 2 created the first ever American national executive, the President of the United States, elected indirectly by an electoral college, a shield against direct democracy and the domination of large population centers. The president was to serve a 4-year term with the option of perpetual re-election. We saw that ended with Roosevelt. He had the authority to appoint all executive officials and federal judges with the approval of the Senate. Most important, the president was to be the major architect of the American foreign policy, serving as the civilian commander of the in chief of the military forces and generally designing and executing foreign policy with the advice and consent of the Senate. Perhaps the most significant power given the president was the executive's ability to veto congressional laws subject to an override vote by Congress of 2/3 of the members, checking an otherwise mighty chief executive. Okay, so that's where I'm going to stop. Next time, we're going to read what a woman had to say about the Constitution. Mercy Otis Warren was the sister of James Warren, and wait a minute. Excuse me, hold on. I'm sorry, I said James Warren. It's James Otis. She's the sister of James Otis. And Mercy Otis Warren thought that even with the Bill of Rights, that the Constitution gave too much power to the federal government. So basically what you're going to read next time, what we're going to read together, is a modern day libertarian woman stuck in 1788, 1789, objecting to the Constitution because it gave too much power to the federal government. Okay, that's where we'll stop today. Now, folks, listen, Sound of Freedom is doing incredible. It crossed $110 million yesterday. This can be the next Sound of Freedom. Now, I know it's not about child trafficking. I know it's not about the crucifixion of Jesus, but having a honest, uplifting, hope-inspiring history of our nation told on the big screen. Now, I don't know exactly how we're going to tell it. I'll be honest, we haven't drafted that screenplay yet. We're doing it one step at a time, but it will be awesome. Whatever we come up with, it's going to be an awesome telling of America's history. And we plan to follow it up with individual episodes whereby we go step by step through all the generations in America's history, all the big events. Help us make this. Visit the site, Wild World of History, and buy Larry a coffee. Help me out. Okay, I'll see you guys back here on Wednesday.